Okay.
Matt, you want to turn off your computer?
Okay, we're live.
Okay. Let's go and get started?
Yes.
Okay. Good afternoon. So for those of you that don't know me, I'm Jessica Cook. I'm an attorney with Foundation Title and Escrow, located here in lovely Johnson City in the Peerless Center. And this gentleman that I will claim as my better half is JR, and he is partner attorney at Page & Cook here in Johnson City, and they focus primarily on family law. So today, as you see in front of you, you've got outlines, and we're covering what we like to call, for better or worse, real estate and divorce. So kind of a little background on how this came about. I was noticing in my practice that we're dealing a lot with sellers who are currently going through a divorce, and they're under contract, and a lot of times the agents have not been fully prepared for what to do and how to handle those situations. And we, as a title company, get the kind of pushback from it. So we put this together. I'm gonna let him start off, and then we'll kind of tie it all together for you guys.
Box lunch in here.
Thank you.
Come on in.
All right,
Come on in.
so I'm going to start off letting you guys know some tips and tricks on how to represent sellers who are going through a divorce and how it may, or buyers in some cases too, and how you guys can better assist them. So first off, you guys are probably already aware, of course, because you're realtors and how to go through the exam and everything and know all that, you owe a duty to your clients. It's not just a weird theory that's not real. There's actually a statutory duty, Tennessee law, and I've attached a statute to the back of your handout here that actually says in the law, 62-13-404, that you guys owe a duty to your clients. You guys are aware of that, but you have a duty to obey all lawful instructions and also a duty of loyalty. And that's the one that I'm really going to focus on today, the duty of loyalty, and how that can get a little sticky when representing clients that may be going through a divorce. So obviously the first one is to obey all lawful instructions of the client when the instructions are within the scope of agency. And secondarily, or not secondarily, but second, you have to be loyal to the interest of your client. Now, a client must place, a licensee or realtor must place their interest ahead of their client's interest ahead of their own. So you guys just need to be aware of that. The client comes first. And so this is where it can get sticky in a divorce. So anybody know the average length of marriage?
6 years. 1 year.
Let's say nationwide.
We'll go 1 year. 3.
1 year.
6.
3 years.
A year and a half.
Dustin's more optimistic with 6. With a happy medium 5.
Lifelong, forever.
Can we just do it?
I'll be out of business.
Yeah.
It is, so Dustin's the closest one. It's 9.5 years actually.
Oh, wow.
You got a mug reserved for you, sir.
Actually, matter of fact, I
9.5
can get it right
years,
now.
average length of divorce nationwide. So almost 50% of all marriages end in divorce. Pretty crazy statistic, but that is a fact. 41%, or I'm sorry, 60% of all second-time marriages end in divorce. And for third-time marriages, a whopping 73% end in divorce.
Oh, Lord.
I'm
on my third
so,
one.
let me get how this
Really?
affects you guys.
Bet you've been
Is
on
that
that one
this
for a
is
long
happening,
time.
this is real.
20 years.
But most people's biggest asset in a divorce is either their retirement account or their real property. And that's where you guys come into play. And so when you're representing sellers that may be going through a divorce, you're trying to sell their home, whether it's because it was court ordered to be sold or whether it's because they jointly agreed to sell their property, split their assets or their proceeds in whatever way they deem fit. You know, there might be a house to be sold or real property to be sold in a divorce. And so when you guys are representing the sellers, you need to be aware that that's something you probably don't want to disclose to the other realtor, the other party involved. That's a sign of weakness. That's a sign of desperation. That gives the other person, the potential buyer that you're negotiating with, that property might be court ordered to be sold in a certain time frame, or it's going to be auctioned off. And so you don't want to give them that insight that there could be some time constraints here. There could be some type of court order or mandate that they have to follow to keep the fact that your client's going through divorce top secret. Don't voluntarily disclose that information. Bad idea. Now, if you're representing a buyer, that's something you may want to know. And you may want to know that because if the court has forced to sell the property, it could be in a court order, which is public record, the price that the sellers are forced to accept. And so if you know that the court has ordered, or the parties have agreed that they must accept every offer over $100,000, you know to come in at $100,000, okay? Plus a buck, and they're required. So if you don't know that, you can be coming in at 110 or 120 and costing your clients an extra 10 or 20 grand because there's a public record that told you exactly what they had the other side to accept it for. You guys didn't look, you didn't know about it, but now you do. So if you're representing a buyer, it's always good to find out, if possible, if there's any inkling or any reason to believe that the sellers are going through a divorce, find that out. There's different ways to find it out besides just simply asking, because that can be awkward, but you can ask. You can go to tncrtinfo.com. That's TennesseeCourtInfo.com. tncrtinfo.com. It's on your handout. It's not on your handout actually, so write that in. tncrtinfo.com. You can click on the county. Not all counties have it online. Most of them do. You click on civil, and then you type in the parties' names you're looking for. Generally, the stuff is stored, and you'll be able to find out if those parties are going through a divorce currently or have recently went through a divorce, in which there may be public court records available that mandate a sell of property for a certain price. Now, I do divorce. That's 99% of what I do. Divorce, custody, adoptions. Everything family law related. Unless it's a current client, I'll do other services for them. But me personally, I know not to put that stuff in a public record. I have my clients who are going through a divorce sign a confidential settlement agreement in regards to their property, so that is not a record. So if you're trying to find something to do with my clients, you're not going to find it, because I do it in the best way I think to do it and make that confidential, so I don't give my clients that exposure that they wouldn't otherwise have. So you're going to be looking in the court record, or in the court file, you're going to be looking for a judgment of divorce that may sell the property for a certain price or within a certain time frame, or you're going to be looking for a document called a marital dissolution agreement, okay? MDA is what it's short for, or what it's long for. So if you're looking for that MDA, if you go through there, you may find a section that says the real property at blank address shall be sold in blank time frame for such price. But they must accept this. There's going to be all kinds of terms and conditions in there that you guys, as negotiators for your client, could otherwise know and help. So, and be aware of that. Like I said, don't volunteer disclose it. If you're representing the sellers, if you're representing buyers, do try to kind of poke around and find that information. When you're looking at a house with the buyers, I mean, look for signs of a divorce. Is this a big old house and you're only seeing, women's clothing in it? Does it look like only one person lives in this giant house? That could be signs that somebody's recently moved out or they've recently divorced. Are there photographs on the wall of somebody that now appears single? Are there photographs been removed from the wall that a bitter spouse would otherwise do? Never see that happen. Look for those obvious signs, because that's going to help you in negotiation if you know that information. Going to the duty of loyalty, though, back to what I said about the duty of loyalty. You're going to owe the same advice to both clients. If you're representing both of the sellers that are going through a divorce, you owe that duty to both of them equally. You may know one of them personally, but that does not mean you can short the other person the information that you're providing. And that can be a hairy situation. So make sure that you are giving that same advice to both in order to meet your fiduciary responsibilities. Stay out of the arguments, okay? It's very easy to get wrapped up in spouses bickering. Stay out of it. Always recommend telling the clients to, try to figure out the differences. You're not a mediator. You're not a judge, you're simply the realtor that represents them both equally, and that, you know, they need to discuss their problem, whatever it is, and come back to you with what their decision is, whether it's an offer, or acceptance price, or how to stage them, whatever it may be. Any type of contingencies, let them figure it out. No, you can help them with just facts. You can help them with straight numbers and facts and help them resolve an argument just based on that. But don't get into the pettiness of it all and appear to take sides, okay? Because if one spouse feels like their realtor is out to get them because the wife's the one that called them, it's going to hinder your relationship with the other spouse. So make sure you're treating them equally and resolving differences with facts and numbers and not getting into pettiness or emotional side of the arguments. Another way to protect yourself as a realtor is to document. Very important. There's all kinds of times in which I've had to subpoena a realtor to court in a divorce or after a divorce because a realtor was handling the transaction and it blew up and one party blames the other party, and I have to subpoena a realtor to court. I try to avoid that because I know you guys are busy, and if you're in court, you're not making money, so I try to avoid that. But there are times in which I've had to subpoena realtors, and there are times in which realtors get sued because one of the spouses thinks they breached their fiduciary duty. I actually have a case right now where my client was awarded the house, selling the house. Even though my client was awarded the house, the husband feels like he was shorted by this realtor who really didn't owe him the duty because my client had already been awarded the house post-divorce. He's suing the realtor. She's involved in a lawsuit now. And has to pay an attorney to go and defend her and do all these things. And she has to prove that she didn't breach her duty. And if she documents, that means she's going to whip out her emails, she's going to whip out her text messages, and it's all going to be in writing what she's done, okay? So save your emails. I know you guys text clients like crazy, and I know it's burdensome, but I highly recommend at the conclusion of your representation, screenshot or save those and just put them in a cloud somewhere, put them in a file somewhere, because there's a statute of limitations for lawsuits for breach of fiduciary duty. In Tennessee, it's 1 year, typically. It can be up to 3 years under certain circumstances. So your exposure to a lawsuit could be up to 3 years. So I recommend keeping all the writings, all the communications for at least 1 year. Highly recommend 3 years, preferably. But that's going to save you guys. Because you don't want to show up to court and the judge is asking you questions, the attorney's asking you questions, and you're looking a fumbling fool because you didn't say anything, you don't remember anything, you look incompetent, okay? That judge is never going to, send anyone to you guys as a court-ordered agent. So come in looking competent, be prepared, have those text, emails, and documents. So if it gets hairy and your sellers are at each other's throats and they have attorneys, we're just referring them to their attorney. Say, listen, I'm not the mediator. Just talk this over with your attorney. I'm not here to work out this difference. If they don't have an attorney, tell them to hire one. Tell them both to hire one, though, okay? So, as an example in your handout, I have a little key point and example to tie this all together. It's a really cheesy example, but it's the hot celebrity divorce right now. So, example there is Kim Kardashian files for divorce against her husband, Kanye West. Neither Kim or Kanye are represented by an attorney, which is not smart and not recommended. While the divorce is pending, the parties decide to sell one of their many 275 mansions across the world. And one of them includes their lovely Boone Lake home here in Johnson City, Tennessee. So Kim and Kanye hire a real estate agent. Hopefully it's someone here at True North. And they list their property. Kim and Kanye can't agree on anything regarding the property pertaining to listing, staging, showing times, contract price, anything. It's a total disaster. So Kanye calls the real estate agent and expresses his frustration with Kim. And Kanye tells the real estate agent that Kim takes his money when he's in need and that Kim's a trifling friend indeed. She's a gold digger. The real estate agent tells Kanye he should retain a divorce attorney immediately and proceed against Kim since she is being so difficult in the transaction, and the real estate agent ends the call. The agent takes no further action. So, has this agent fulfilled her duty of responsibility to both parties, or has she breached that duty?
She breached it.
Absolutely breached it. She told Kanye to go hire a divorce attorney, end of the call, and didn't follow up and do anything else. That's it. The ideal scenario there would have been, you know, you both need to work this out with divorce attorneys. She needs to tell that to Kanye, she needs to tell that to Kim, preferably in writing to both of them. You know, that's a scenario where she shouldn't be giving this extra advice to one party and not giving it to Kim. Telling Kanye to go hire the best divorce attorney in Johnson City, J.R. Cook, is not fair to Kim. So she breached, okay? So I always recommend if you're representing divorce sellers, copy all of them in the same email, okay? They're getting all the same information. Start a group text. If one spouse calls you and is on a call, say, hey, let me loop in your wife, let me loop in your husband, let me add them to a conference call so we can all do this, so we're on the same page. That protects you guys, okay? Because obviously, number one, you gotta look out for yourselves.
What if they hate each other with a passion? Should I keep them in separate things in which I'm giving the same information just independently? Does that
You can do that. You can absolutely do that. If you know that as soon as one reply is all, it's gonna stir up crap and exactly, totally fine to keep it in separate threads, separate transactions, but make sure it's the same information. That's the key. You don't want to ever be in a position where you've given what could appear to be extra advice to one spouse over the other. Good question.
So the divorce rate in America is 50%. So how many of you all have already worked with somebody that's going through a divorce? Matt? So the likelihood is that at some point in time throughout your careers, you're gonna work with somebody in this situation. And so I, like I said earlier, brought this up to him to kind of talk more about and see how we could collaborate to educate realtors, because when it gets to us and we get the contract and we're contacting whatever sellers, the one we have contact information for, and we're saying we need a copy of your marital dissolution agreement, we need your final divorce decree so that we can continue processing, and we have to determine who's gonna sign at closing, that kind of thing. Let me tell you, every single time it starts a firestorm. I mean, people are just pissed off that we're even asking for this information. Why do you need this information? How could you do? And then it starts a, I don't even talk to him. You know, like it's a whole thing. So if you guys can be better prepared on the front end, and I mean like when you're putting together your listing presentation, your listing agreements with your clients, to say, okay, when you get to this point, when we're sold, we're under contract, we're the title company, here's what they're gonna need. Go ahead and have that information available so that they're not caught off guard. Because what I'm finding is that when we ask for that information, when we get an earful, the next person that gets a phone call is you guys. You get an earful, and they're just pissed off because they're going through something that's super emotional for them. So the point today is to better educate you guys so that you can better educate your clients, and we get to the closing table smoothly and on time. Because also what I see is that just that one phone call can spark such emotions, and then it starts a fight between the parties that we don't actually end up to the closing table on time. And that's where we get into some really hairy situations. So when you are talking with your clients, preparing them that we need a marital dissolution agreement, we need a final decree. That's not just for sellers that are currently going through a divorce. If you're representing somebody that's recently divorced, we need that information. We have to determine who's gonna sign the closing documents. So, and that's what those documents prepared ideally by their attorney will tell us. It'll tell us.
The final decree and the MDA.
Yes, and what I'm first of all looking for is, was there a quitclaim deed executed by one party conveying title to the property to the other? Mm-hmm. That's what I'm looking for. Lots of times that doesn't happen. It's prepared or it's put into the MDA by the attorney, but these divorce attorneys kind of forget that piece of it towards the end, and they either, not him. Exactly. Definitely not him, but they're either prepared and they're just sitting in a file somewhere, or they never got prepared, but either way they didn't get recorded. So if they're not recorded, then it's ineffective.
And a lot of spouses think just because they're MDA, and that's the marital dissolution agreement, that's the contract between husband and wife that settled the case if it did settle. A lot of clients think, oh, this is it, this is all I need, I don't need a quitclaim deed, it says in here I get the property. And that's what she's saying is definitely not it for the title side of it. For the court side, yes, that says that they're the owner for the court proceeding. But as far as legal title, You need the
Yeah.
quitclaim deed.
Yes, we need the quitclaim deed. Go ahead.
Two questions. One, if it is quitclaimed over and we can see that reflected in the courthouse retrieval system, do I need these additional documents?
Yes,
Okay.
because, and here's why, that's actually the next thing I was about to say, is that, sometimes in these documents, it's not as simple as one spouse is gonna convey out their interest in a quitclaim, via quitclaim deed to the other party. There's gonna be some monetary obligations involved there, and we have to collect for those on the settlement
Oh,
statement.
so you need that,
So
so
we
if
have
like
to
you
have
get
that-
it, you sell it, but if you get
Yeah.
above a certain amount, I need this kickback.
Cause
Yeah, there
if
could
this
be
spouse is,
percentages.
if this spouse is not paid out, it becomes a lien on the property,
Yeah.
then the spouse will lien on the property.
Okay.
So we have to see that to make sure that we are collecting any dues owed to the other spouse, or potentially there are some credit card bills, different things that are negotiated that are specifically to be paid out of the proceeds of the sale of the property.
Absolutely, that's very common,
And
actually.
so we have to make sure that those items are also included on the settlement statement so that we are following the court order. I mean, it's a court order, so when the
Right.
sale of the property is included there, we have to do everything just right. So yes, all of those documents, go ahead and prepare them, even if there is a quitclaim deed that's signed and recorded, we still need, everything. I wanna look at all of it, because I wanna make sure we're covering our bases.
That's definitely best practice.
Yeah,
And the
absolutely.
second question is if Mickey Mouse, the divorce attorney, has this file, doesn't follow up to set up the quitclaim, and it's just in the file, cause that like exact statement came in and somebody wanted me to list their land. So I have the documents, I own it, I'm like, I see her name right here as owner. And, well, she's not talking to me. I'm like, well, she has to sign, cause it doesn't matter, you can get above asking price or whatever, but if she's not signing, I can't just pretend like you're the sole owner, or else it's
Yeah.
gonna get hairy.
Yeah, and those are the questions, and that's why I say ask them up front when you're listing it, because what we're finding is I'm working with divorce clients or going through a divorce, recently divorced, whatever. We get to the closing table, they've signed that quitclaim deed, but the other party is actually nowhere to be found, or the quitclaim deed didn't actually get signed, so we don't have anything to record. And that other party is in Hawaii and won't speak to anybody. Well, now we're at a standstill.
Yeah.
What are we gonna do? And that's when hopefully the other party who's selling the property has a good divorce attorney, and they can probably file something in court or something, whatever, but we're still delaying closing, and we're incurring attorney's fees and everything else, so.
Okay.
Which probably comes out of the proceeds of everything,
Probably.
right?
Yeah.
That would
And-
be, yeah, that would be crazy for court orders.
Yeah. Another thing, that I actually get to see on my end, and you can speak more to this, is that when you are negotiating the sale of real property, at what point do they say, okay, what's a list of certain, real estate advisors that you're gonna have, that you would want to have involved in the sale of your real property? And then they
Absolutely.
start a negotiation back and forth on that, which you may receive phone calls or something.
Yeah, it's not uncommon at all for, as part of the negotiation processes, to, all right, we're gonna, we've all agreed to sell this property, now how are we gonna sell it, what's the list, who's gonna list it, all this stuff. For attorneys to exchange realtor information, very common. Sometimes, they can pick amongst themselves, the clients or the attorneys, and then other times, you just submit your proposed realtor, your list of realtors to the court, and the court just dictates and picks the realtor. It's not uncommon at all to happen.
Yeah, yeah. So with that said, seeing so much of this, I'm finding that realtors are really, can find themselves in a huge pitfall when dealing with clients like this. Not even just this, estates, and that could be a whole other topic. But, I think the biggest takeaway for today is that if you are working with clients going through a divorce, you've obviously got resources here to come to if you've got questions, but document everything. Because he has put realtors on the stand who did not document everything, then you totally lose your credibility with the judge. And then you kind of lose your credibility, period, as a real estate agent for anybody that's in that courtroom observing. So it's.
Question, sorry.
Yeah, go ahead.
I had a buyer recently, and I've had it on the seller side before where they had to do like the divorce decree and all that. But I had a recent divorcee, and she was already divorced, all that good stuff. But before we could close on a new home, she had to turn in, I guess, her divorce stuff. If she was already divorced, why would she have had to do that when she's buying a new home? Which she didn't question it, she was okay with doing all that, but it was new to me, I didn't understand why.
So the divorce was final,
I'm
and she was
pretty sure the
buying.
divorce was final and she was buying, and the lender, I guess, or the closing company required that she have something sent in for the, it was, I guess it was a quitclaim deed from the husband, or the ex-husband or something. That's what it was.
Was she selling and buying at the same time?
No, she wasn't selling. I think they had already sold, but she had nothing on our purchase, that no contingencies or anything like that. She was buying straight up.
Did
She
she
was
get
pretty on her own.
Did she get proceeds from the divorce that was a result of a quick claim or something that came over?
That's gonna say,
Or,
that
yeah.
could be,
Or was the divorce,
I'll be honest, I didn't question it because everything just flowed and she did everything that was required. I just thought it was kind of odd to be on the buyer side.
yeah, I'm trying to figure that out, I'm not sure, but if the divorce was somewhat recent.
It was.
There's an appeal period,
And that's probably
and that,
what
it
it
may
was
have
real
been within that
fresh,
appeal
so
period where they
Yeah.
needed to see.
that's
that
probably what it was.
information. When you say-
yeah.
Because it wasn't anything that was like, it just kind of popped up and they're like, it's no big deal, we just need to see this. So that's probably
Yeah.
what it was then.
Yeah, and that's where, that was a good transition into what he's talking about, this appeal period. So that's, we've got people, okay, they say their divorce is final, well, they have 30 days from the time that the judge has ordered final decree of divorce, there's 30 days to appeal that. So that's why I'm looking for quitclaim deeds to already been signed and taken care of, but then when you've got that 30-day appeal period, you wanna talk about the suburban property? It is now, was under contract and sold, and now it's not.
Apparently, being appealed, so the whole judgment could be overturned. So the title company, if they're not careful, and the realtors aren't careful, they're gonna convey this property to somebody that's technically not fully owned by the seller, because it's being appealed, and then if that judgment's overturned, talk about a disaster.
So if you're in
Oh
that
my
30-day
God.
appeal period, what I like to see is that both parties go ahead and sign everything. Because even though we're signing a quitclaim deed, they're still technically married, and we're in that 30-day appeal period.
Wow.
So
Okay.
that's why it's very important that we need to have the conversations up front, that you could be required to, both parties to sign documents at closing, depending on, and it's a case-by-case situation, right? So it depends on where we are. So that's why, for you guys, I would say, you know, let us be resources to you. If you find yourself in that situation, okay, here's the scenario, what do we need to do, and we can kind of talk you through it.
And it's not common that somebody appeals, but it's possible,
But it
it does
happens.
happen. Like she said, I have one that's currently happening right now.
Yeah.
We'll win.
Good luck with that.
We'll win. Fine. He's being a nuisance, the other party's just being a nuisance.
Yeah, I find that to be usually what they're really trying to get at is just to frustrate the other party.
It is, and then, you know, it ends up delaying closing for everybody. So, you know, and like I said, the takeaway for that is, I may need both spouses to sign at closing, and if I don't have anything telling me otherwise, and they're both entitled, they both sign, and the proceeds check is made payable to both of them, unless we have something telling us differently in writing.
And that's good practice for you guys too, to help your clients understand that, because you don't want them, if this all falls apart, looking at you and saying, well, you didn't tell me this was possible, you didn't tell me they may need to sign.
Yeah.
You know, this has helped
Yeah.
educate clients, make you guys look
What I
even
see
better.
too is that when you get a property under contract, or you're working with the sellers going through divorce, you get a contract, and only one party has signed it. That's a big no-no too. Both parties have to have signed that contract if they're still entitled and still in pending litigation.
Okay. What if the divorce is final and quitclaim has already been processed?
I think at that point, you're okay, but I would say double
There's
check.
one that there's zero way I can get him to cooperate with me.
Yeah, I mean,
Yeah, at that point, once the quitclaim deed is
Absolutely,
signed, if
that's fine.
everything's final, you're good. If they're still
Going
in
through
limbo,
things.
yeah.
So in that instance, if somebody is kind of going back and forth, it's probably best to kind of wait for the things to kind of fizzle, to be finished, let it fizzle, maybe even 30 days, and then begin the process.
ideally, yes.
Yeah.
Ideally, divorce is final, 30 days have lapsed,
Okay.
then make the purchase. That's the ideal scenario.
Okay.
There are those clients I know that wanna go ahead and get a house now, they wanna move on, and divorce is not final, they think it's gonna be agreed upon, and it gets sticky, okay?
Yeah.
Because the other party may then stake a claim to that property, well, you bought it during the marriage, and technically anything acquired during the marriage is marital property, generally speaking at least. So, exactly, if you can avoid it if possible and do it at the end of the divorce after it's all final, that's the ideal scenario.
And if you have a buyer coming to you and they are still going through their divorce, I would highly recommend you tell them to make sure they've spoken with their attorney first, that they have the attorneys go ahead to proceed with buying a house while their divorce is still pending.
Yeah.
Okay.
You don't want the other spouse trying to stake a claim, and that's kind of out of your hands at that point, but it would be good practice for you to say, hey, maybe have you consulted with your divorce attorney on whether or not you should do this, or should we slow down? And if they have, then, it's on them, the divorce attorney.
That's on them, yeah, because
But,
you've been hired to sell a property, not give
But as a
people back.
divorce attorney, if I advise my clients, do not buy property during divorce, please, that's a bad idea. But if they're willing to, if they want to do it, they tell me they're gonna do it, and it's just too bad, they appreciate my advice, but they're not taking it, I at least have the other side confirm in writing that this purchase is gonna be my client's sole and separate property, it's considered settled, and that protects them.
Okay, yeah.
Yeah, in the event of your first example of said realtor who is working with, one divorced spouse that has been quitclaimed over, that's been done, and then they go through the process, and then that person sues said realtor saying, well, that person was looking out for me. Well, your fiduciary duty is only owed to the person who hired you at that point. What is the best practice there? Just continues to document, hey, my name's Samantha and I want to use my realtor. Great, Samantha, and not like Samantha and Joe, but I'm talking to Samantha.
So are you saying, or is it a buyer or seller?
It sounds like whatever that first example was, where it's like you're meeting somebody who's gone through the divorce, and then disgruntled divorced spouse is like, hey, well, that realtor sucks.
Okay, gotcha.
Give me this, and then now they're pulled into
Yeah,
it.
so if the divorce is final, and say you represent a wife in the real estate transaction, their ex-wife now, right? And so it's final, you represent the ex-wife, and she was awarded the property, and the quitclaim deed was signed by husband, and she is the legal owner, and the NDAs and the quitclaim deed. I don't think you owe a duty to the ex-husband. He's not part of the contract, he's not an owner of the property at that point. I would, he's a non-issue, but.
But the E&O kick in with it.
Well, you know.
Totally doesn't get that far, most of the time doesn't, but
Okay.
in the event that does,
Okay.
be prepared to show that,
So
hey,
text,
if she was the owner, he was not the owner, he wasn't
Yeah.
part of this relationship at all, he's come out of nowhere.
yeah, so text messages are considered, written, proof as far as like,
You can form a contract via text message,
okay.
yeah. Technically, a contract for real property has to be in writing in Tennessee. But as far as like an agency agreement and stuff like that, a text, is
Yeah.
considered a writing. You can
Okay.
have a contract for a $10 million property written on a napkin, and it's valid.
Okay.
Mm-hmm.
Interesting.
Joey?
I'm gonna
Be prepared. My next contract will be on a paper towel.
Scan it in.
Great questions. Does anybody else have any other questions, comments?
Hey, did you talk about removal of the title of the property versus removal of the mortgage?
Well, yes and no. So when we're talking about removing the mortgage, which is not really gonna affect you guys too much, but, that's when the refinance has to take place. And we're gonna refinance to get that spouse off of the current mortgage too. So,
Okay.
yeah, but now if we're selling the property and they've got a mortgage on it, we're just gonna go ahead and do payoff unless there's something different that's been negotiated in their NDA. We'll go ahead and pay off everything at closing, and then the net proceeds will be divided however we are instructed to do.
Okay.
So,
I have one more for you.
okay,
So, you represented a husband and a wife, you were the fiduciary during that transaction, hugs and kisses, everybody's happy, life goes on, the old 50% rate takes into effect, divorces happen, somebody calls crying, oh my gosh, this guy left, can't believe it, what should I do, they've got an attorney against me, do you have an attorney? No. Is it then outside of both clients' interest for me to suggest that person get representation?
I don't think so, because I think I'm not positive, let me rephrase, because your relationship with them effectively ended
At the transaction.
at the transaction.
Yeah.
So I think it would,
At that point, I'm just a buddy who sold him a house.
could be, unless I don't know, I know lawyers owe past clients a continuing duty, no loyalty. I don't know how that,
When we do an
is with realtors.
exclusive representation agreement, it is a certain time limit or when the
Okay.
transaction ends.
right.
so if that's how it's worded,
Yeah.
I think you'd probably be okay
Okay.
to say
It would if I did represent them too, one's represented and I recommend, well, he has an attorney, maybe you should get one. Is that still kinda, I'm going against one or the other, or is it suggesting?
repeat that again.
he had an attorney, I'm divorcing you, said lady.
Mhm.
Lady is crying, what should I do? You
Gotcha.
should get an attorney.
I would phrase it as, I'm not an attorney, I can't give you legal advice.
You should.
If you need legal advice, you speak with an attorney.
Yeah.
Would it?
That's not you
Okay.
directing her to go proceed against her husband. You're just saying, I'm not an attorney, you just with an attorney, it's a legal question.
Okay.
Okay. Yeah,
It's the best way to
because
phrase
I'm
that.
sure you all have at some point been warned that you could easily end up in a gray situation where you could be perceived as unauthorized practice of law.
Which is a crime,
And
it's a
that's-
misdemeanor.
Yes,
Right. That's
Yeah.
the most common thing realtors get sued
Yeah.
for, is trying to be attorneys.
yes, it's a fine line, so I think phrasing it like he said protects you guys all the way around.
Cool. I often say I'm not a home inspector, don't sue me, so I'm not a lawyer, don't sue me. Seek legal advice on
You need to add that one, yeah.
Oh, catchphrase.
All right.
Any other questions? All right, let me do a quick calculation, one more fact for a door prize.
I won't answer this time, guys.
45 minutes.
I'll let somebody else play.
You don't wanna win them all, do
Anybody
you?
know- Can anyone guess how many divorces occurred in the 45 minutes that I've been here? Approximately.
In America,
Yeah,
37.
a million.
a
But you-
million.
Wow.
You're such a nut.
I'd say 50.
In 45 minutes?
You're such a,
Golly, no.
You said 50,000?
I said 50.
Callie, you're such a pessimist.
Just a minute, guys.
I am.
It's 45 minutes, Jesus, people. 180. That's
180?
About every 13 seconds.
Jeez.
Yeah, about every 13 seconds there's a divorce. So if I did math correct, I think it's about 180, give or take some. So basically, 9 divorces occur in the time it takes to recite vows. In the time it takes one couple to recite their nuptials, 9 divorces has happened.
Dang, it's really crazy.
So,
Oh my goodness. You guys are wild though.
there you go.
Like,
I don't know who Matt, you said 100.
I did.
You get a mug too.
Yay.
Well,
And
we-
I-
Welcome to the Mud Club, bro.
We appreciate your all's time today and allowing us to get in front of you and present our little.
Thank you.
Well, thank you all. It was very helpful.
You guys found it valuable to your business.
Absolutely.
And hopefully you see the value of working with a title company that has an attorney on staff. So, because we have a lot of these kind of things that come up, and I'm always.
You wouldn't go to a doctor, or you wouldn't go to a hospital that didn't have a doctor. Don't go to a title company that doesn't have an attorney.
I like that. Screw your tagline.
If I can help you guys out, if I can help your clients out, that's going through a divorce or a family law related matter, feel free to give them my contact information. If you guys have a question, you've got my contact information, my card's in all the cups here. Google me, Matt, you know how to get a hold of me as well. Reach out, you can use me as a resource. I'll call you back if I'm not in court or something. I usually return calls or shoot a text back or an email as quickly as possible, so I'll help in any way I can. Informational purposes only, it doesn't establish a attorney-client relationship.
Thank you, JR.
Disclaimer.
And Jessica, we appreciate you and Foundation Title being an affiliate.
Yes, absolutely.
So,
Thanks for having us, guys.
thank you all. Thanks for lunch.